Hi, I'm Warren Redlich. I'm the Fair DUI lawyer. This video is about DUI checkpoints, and in particular, it's about DUI checkpoints and other checkpoints by NYPD, the New York City Police Department. I wrote a book about drunk driving, DUI laws, etc. It's called Fair DUI, and I also became somewhat famous for the Fair DUI flyer. As you can see, I got a lot of attention, and the Fair DUI flyer got a lot of attention in the news. It was featured in the Associated Press. It was featured on Fox News, it was featured on CBS News. And of course, for fun and other reasons, I actually got myself arrested in a DUI checkpoint in Coral Gables, Florida. And that might come up again in this video. It was different, and case was ultimately dismissed. That's a long story that we'll cover another day. I'm working on a case that involves NYPD. It's a checkpoint that happened in NYPD that I believe was handled wrongly. I'm going to talk about the history of checkpoints in the United States, law around checkpoints, and how NYPD doesn't follow the law, doesn't do it right, all the things that are wrong with NYPD checkpoints. That's useful particularly for people in New York City to understand, but if you're somewhere else, it may be useful to see how NYPD does it wrong and how it's supposed to be done, so when you're looking at checkpoints in your area, you can see, well, how are they supposed to do it and are they doing it right? So now let's talk about checkpoints, court cases, and NYPD. Well, NYPD does a lot of checkpoints, and they do them pretty badly. Now, I'm not going to get into my case, but I'll put some of the documents from my case up on the Fair DUI website, fairdui.org. There'll be a link in the description for that, and you can look up that if you want to. But really, it's just sort of a wait, how is NYPD doing checkpoints? How are they supposed to be done? So let's get into that. The court started wrecking the Fourth Amendment with regard to cars during alcohol prohibition. It started in 1925 in a case called Carroll versus the United States. It's an alcohol prohibition case. Prohibition agents wanted to be able to stop cars and search them. And the Supreme Court ultimately said, yes, they can do that. And that was the start of the erosion, or one of the early beginnings of the erosion of the Fourth Amendment. At the time, it was thought that stopping every vehicle would suit the purpose of despotic power, but it would go against the pure atmosphere of political liberty and personal freedom. Chief Justice Howard Taft wrote the majority opinion in the Carroll case. The former president is thought by many to be one of the greatest Supreme Court justices we've had in the country. While Taft and the court started eroding the Fourth Amendment in Carroll, he was clear then about the idea of stopping every car. He said it would be intolerable and unreasonable to stop every car and subject everyone to the inconvenience and indignity of a search, and that we are entitled to free passage without interruption unless there is probable cause. So a checkpoint is something where there's no probable cause, no suspicion, you're just stopping cars because you're stopping cars. And they didn't even contemplate the idea of having checkpoint stops in 1925. NYPD checkpoints are a useful way to talk about all this. They're done as part of a policy now called Patrol Guide 221-16. It's a 3-page document. There's not a lot of substance to it, but let's look at some of the highlights from that policy. The checkpoints are supposed to be set up by the precinct commanding officer. As I'll explain later, that's not really appropriate, and they don't follow that policy anyway. They're supposed to be handled in a non-arbitrary manner. They don't follow that either. They're supposed to have adequate warnings to motorists. Of course, they don't. The only purposes mentioned in the patrol guide are for a DUI check or a vehicle safety check. That's a lie too. They do them for other reasons, and they're pretty obtuse about even saying what the checkpoint is for in practice when they prepare paperwork, if they prepare paperwork. Speaking of which, there's supposed to be a vehicle checkpoint form prepared by the commanding officer, and they're supposed to go over that with the officers who are running the checkpoint and operating the checkpoint. Well, the commanding officers don't do that. They don't prepare the form. If a form is prepared, it's maybe done by a sergeant. No one goes over the form with the guys who are actually operating the checkpoint. If they fill out the form at all, they don't do it right. So on this actual form, you can see that the commanding officer line is blank. They didn't even fill it in. On the reasons for the checkpoint, they're supposed to explain a bunch of things about how they did the checkpoint, why they're doing the checkpoint, what the purpose is, and so on. They don't explain anything at all. They just put a few words down. They're supposed to assign a point person, but they don't. They're supposed to keep records. No, they don't do that either. The big case that matters for us here is Michigan versus Sitz. Chief Justice Rehnquist and the Supreme Court decided that so-called sobriety checkpoints don't violate the Fourth Amendment. In the 1970s, Rehnquist was part of a decision to allow a permanent immigration checkpoint in United States versus Martinez-Fuerte. Justices Brennan and Marshall then dissented about what they called the evisceration of the Fourth Amendment. And they dissented again in the Sitz case, saying that the court was undervaluing the intrusion and exaggerating the law enforcement need. There's two big issues here. First of all, the courts are exaggerating that law enforcement needs to use checkpoints to enforce laws like drunk driving laws. And second of all, they're understating the impact that these checkpoints have on regular people who are driving through them. The checkpoint where I was arrested, they backed up traffic for a quarter to half a mile. And I don't remember if they made a single drunk driving arrest after, basically wrecking the night for a ton of people, just backing it up, giving everybody a hard time. It's not what it's supposed to be. Well, dissents are on the losing side. Rehnquist, writing for the majority, said it was okay, and he noted the extensive effort made by the Michigan State Police to do it the right way, with an advisory committee setting guidelines, picking locations, and the operation done to minimize the delays to an average of 25 seconds. And they used trained officers to do field sobriety testing as appropriate for the individual traffic stop. And as an example of that idea, you can see that when I was arrested, there was a mobile breath testing unit at the checkpoint in Coral Gables. They actually had 3. I don't know why they had 3, but they had 3. Michigan versus Sitz followed a lot of discussion in law review articles and state courts about whether checkpoints would be allowed and what factors the courts should consider. 2 big cases at the state level were State versus Deskins in Kansas and Ingersoll versus Palmer in California. These are cases that have been cited widely. A lot of other state courts have referred to these cases when they were making their own decisions about how to handle checkpoints. They looked to these courts because they had done extensive analysis. Deskins and Ingersoll both set forth a list of factors. Each has their own list, but they're very similar. A list of factors that the courts are supposed to use to balance whether a checkpoint is appropriate under the Fourth Amendment. Now, I'm going to go through those factors, and we'll go through and look at how these apply to NYPD checkpoints and how it might matter in other checkpoints. One of the big things that both cases talk about is that decisions are supposed to be made at a supervisory level. So in Michigan versus Sitz, the decisions were made by an advisory committee setting guidelines and choosing locations. And that was a factor that both of these court cases considered, and a lot of other court cases when they talk about who's making the decisions about how the checkpoints are going to be conducted, where the checkpoints are going to be located, what kind of other things are going to go on at the checkpoint, what are the rules that the officers are supposed to be follow. In most of the cases that I've seen, these decisions are supposed to be made at a high level. Supervisory level, up at the top, advisory committees, the elected officials are supposed to be making these decisions. Well, NYPD doesn't do it that way. The official NYPD policy specifically identifies precinct commanding officers as the ones who are supposed to choose the location and set up the guidelines that are supposed to be followed for these checkpoints. And the first thing I would tell you is precinct commanding officers are not high up enough in the food chain to be making that kind of decision. There's just simply not that level of official. They're really just administrative bureaucrats who are just trying to get through their day. They're not thinking about the larger issue of, gee, where is our drunk driving problem serious? Or what other problems do we have? And what policy choices should we make? They're pretty much just doing what they're told. And anyway, precinct commanding officers don't actually prepare vehicle checkpoint forms, set guidelines, decide where the checkpoints are going to be. They pretty much ignore it and hand it off, and those decisions are made by sergeants who are in the field, which is exactly the opposite of what these court cases say is supposed to happen. These decisions should be made at a high level, not at the low level, the guys who are actually running the checkpoint winging it, which is what really happens at NYPD. And unfortunately, I think that happens a fair bit in some other police agencies as well. Basically, NYPD checkpoints are just a mess of arbitrary decisions made by frontline officers with no meaningful guidance, no meaningful procedures followed. It's a mess. It's not the way it's supposed to be. Of course, let's be clear. I think there shouldn't be checkpoints at all. Checkpoints are wrong. This is the United States of America. We have freedom. Just like the court said in Carroll versus United States, just like Justices Brennan and Marshall said, this is supposed to be a free country. And we shouldn't have checkpoints at all. If you've done something wrong, then the police should be able to intervene. If you haven't done anything wrong, they should leave you alone. Another big factor in checkpoint analysis is safety and advance warning. Checkpoints should involve all kinds of steps and equipment to make sure that the checkpoint is prominent, safe, and that people have ample warning that it is coming. You can see here in this motorcycle checkpoint video that NYPD doesn't do anything like this. Nothing like this. Here we are in the middle of heavy traffic. A cop walks out in the street, points a motorcycle to pull over. There's no advance warning. There's no sign saying motorcycle checkpoint ahead or any checkpoint ahead. There's no meaningful safety measures. This is just a mess. And yes, we're going to see more from this video soon. The next factor is location. Locations are supposed to be carefully chosen by supervisory officials. And NYPD's policy has nothing about how locations are supposed to be chosen, nothing at all. Other than supposedly commanding officers are supposed to choose them, they don't even do that, but there's no guidance to the commanding officers about how they're supposed to choose where the checkpoints should be done. In practice, checkpoint locations are determined by sergeants based on whim, just wherever they feel like doing it. There's no indication that sergeants have any plan, any wisdom, any training in deciding where is the appropriate place to do checkpoints. Nothing at all. And doing checkpoints in New York City, particularly in Manhattan, New York County, Manhattan, is particularly inappropriate. When you look at the broad sweep of where drunk driving is a problem in the United States and in New York State, I should mention I'm a New York lawyer and a Florida lawyer, handled a lot of drunk driving cases in New York. When you look at where drunk driving is the biggest problem, I can say for sure in New York State, drunk driving is the smallest place in New York State where it's a problem is New York City. And if you think about it, New York City has a lot of mass transit. One of my big things in my book is if you want to stop people from driving drunk, give them an alternative that's more convenient and less expensive than driving. And that will give the drunks an opportunity to choose a different path. So what we see is that in Manhattan itself, they have the lowest drunk driving problem probably anywhere in the United States. Something like 3 deaths a year in one of the largest counties in the country. It's a very, very small problem in Manhattan. There's no reason for there to be so much attention paid. If a policymaker was making a choice about where to locate a checkpoint to minimize the harm, they would choose a place where there are more drunk driving deaths, where there are more drunk driving accidents. Manhattan, New York County would be the last place in the United States you would bother. It's the last place in New York State that you would bother, and it's the last place in New York City that you would bother. And yet, they do a lot of checkpoints in Manhattan. And that's evidence that NYPD is not using the judgment that was dictated by these court cases as to how checkpoints should be located. Another factor addressed in Deskins and in Ingersoll is time and duration. What time do you set up your checkpoints? How long do they last? Really, there's not a lot of analysis in any of the cases about how you're supposed to consider that, but simply the supervisory level, that is a factor that they should talk about. When are we doing checkpoints and why are we doing them at that time? How long are they going to last and why are we having them last that long? There's at least to be some sort of consideration for how those decisions are made. There's nothing like that in NYPD policy. There's nothing about it in the vehicle checkpoint forms that the commanding officer is supposed to fill out, that the sergeants in practice do fill out. Nobody has thought about this question at all in NYPD, or that there's no indication that anybody's thought about it. Another factor is the length of the detention. The idea is that you're stopping a car. Well, that should be a minimal delay for an innocent person. An innocent person should not be stopped, held up as a result of the checkpoint. Now, in Michigan versus Sitz, they talked about the average delay was 25 seconds. Well, that seems pretty minimal. I can say that in the checkpoint I went through in Coral Gables, they backed up traffic a quarter mile. It was terrible. So there was a huge delay for everyone. If you only count the time that they're in the checkpoint, that's not really a fair way of looking at the delay. You can see in this motorcycle checkpoint video that if you watch the whole video, it took 2 minutes from the time the guy was stopped until he was handed his papers back. It's not even clear he was free to leave at that moment, but 2 minutes is a lot longer than 25 seconds. NYPD is not really doing it the way they should be doing it to minimize the detention. And
I can make life very difficult
you want to catch
for you.
The guilty drivers, but the innocent driver should be left alone as much as possible. And NYPD there's nothing in the policy about how long the detention should be, how long anything should take. There's nothing in the checkpoint guidelines about how to measure it. No interest whatsoever by anyone in NYPD about how do we minimize the burden of this on innocent drivers? How do we minimize the length of the detention? It's not a factor that they consider at all. Now, if you ask me, this is a big one. The cases both talk about, and many other cases talk about, the value of advance publicity. The idea is that advance publicity warns people that there will be a checkpoint. Number one, that's a fairness thing, that people are aware that there's checkpoints out there or that there's a particular checkpoint, so that they're not surprised by the checkpoint and intimidated by the checkpoint, or stunned or distressed by it because they knew it was going to be there. And there's a publicity value. There's this idea that having the checkpoints publicized, and I'm not saying I buy this, by the way. I don't think this is appropriate or a fair way of tearing apart the Fourth Amendment, but the idea that publicizing the checkpoints puts people on notice that the police are out there and it deters drunk driving. I think that's nonsense. You can deter drunk driving all kinds of ways. We already see tons of commercials, stay sober or get pulled over, all this nonsense. There's plenty. You can have other enforcement initiatives like saturation patrols I'll talk about later, and you can publicize them. The value of using checkpoints over other enforcement methods to get that publicity, I just think that's nonsense. To get that deterrent effect, you can get that without using checkpoints. So I think it's nonsense. But in any event, this is one of the factors that the courts talk about. So forget about Warren's opinion for a second. What the courts talk about is this is valuable because it provides a deterrent effect, and because it gives people advance notice there will be a checkpoint to make them more comfortable. They're not shocked. They don't think this is something else going on. They know it's appropriate. And the thing is, NYPD does the opposite of this.
PD has sent a cease and desist letter to Google demanding that it remove alerts about DWI checkpoints on the Waze driving app. Google purchased the crowdsourced app in 2013. The letter comes after Google launched a new feature on its Google Maps app alerting drivers to the location of police speed cameras.
Number one, they don't publicize checkpoints at all. And they even threatened Google and Waze over Google and Waze. So Waze, the Waze app, if you're not familiar with it on Google Maps, they sometimes provide people, you can see that there's a police ahead for a speed trap or there's a checkpoint ahead. And this is a feature in these apps, and NYPD sent a threatening letter to Google about Waze. Google owns Waze, sent a threatening letter to Google telling them to stop publicizing where their checkpoints are. This is, number one, it's wrong that they're threatening the free speech rights of the people who are sending it in and have Google and Waze to say that, hey, there's a checkpoint here. But number two, this goes directly against the principles behind why they're supposedly allowed to do checkpoints, is this value of giving people advance notice. So NYPD is directly in the face of what the policy, what the court cases say it's supposed to be. Nothing in the policy about giving advance notice. In practice, they don't give advance notice of checkpoints, and in practice, they actually oppose and try to stop anyone else from giving advance notice that checkpoints are going to be out there or where they're going to be. Now, the Deskins case talked about both being less intrusive and more effective. Less intrusive, not bothering people as much. You're not supposed to bother innocent people, and more effective, either more effective at arresting drunk drivers or more effective at deterring drunk driving, however you want to call it. The thing about this is that saturation patrols are more effective at making arrests, and as I said before, you can certainly publicize them and achieve the same deterrent effect with saturation patrols. But NYPD ignores this whole concept. If they really wanted to do this, of course, they could do saturation patrols. One of the biggest things about how NYPD does its checkpoints is effectiveness. If you're going to conduct a checkpoint, we have the motorcycle checkpoint video you've seen, there are drunk driving checkpoints. You would use officers who are trained to handle the situation you've set up. So if you're doing a motorcycle checkpoint like the video we have here, you would have officers who actually know what the laws are relating to motorcycles. They know something about motorcycles, and you can see in the video they don't know what they're talking about. They're not following proper procedure. They come up with this cockamamie idea that you're not supposed to have cameras on your helmets.
You didn't get one?
No, look at the ID. Hand it back.
That guy had Miller, what are you doing? You can't have the camera on his helmet.
Yeah, it can't be anything.
Are you gonna inspect the spike? The canoe valve is in this area. Here, I think it's the camera. Because I know guys like to record while you're riding or whatever, but if it happens to fall off, it's more or less just becomes like debris. So
in drunk driving checkpoints, they're not using officers who are trained to make drunk driving arrests. They'll use a cop who's a narcotics officer and they'll put him out there and have him run the checkpoint. When, all these cases that I see in the courts, there are police officers on site in other places who are prepared to do field sobriety testing. They're prepared to do breath testing when necessary. The full breath test, what's known as the intoxilizer, data master in some other places, this idea that a machine that can be used in court to convict somebody, a machine that's reliable, so if somebody's innocent, it'll show they're innocent. I don't really believe in those machines, but they're better than untrained officers doing this. So if you want it to be more effective, you would do it the right way, and NYPD doesn't. They use untrained officers, and that creates even more of a mess. And it violates the factors that Deskins and Ingersoll and other cases talk about how you can do checkpoints better and more consistent with the Fourth Amendment.
You got a statute or code or something I can look up? Because
you can see in the video that the police officer tells the driver, the motorcycle rider, hey, just look it up in the vehicle and traffic law.
I don't have it in the email. We have like a list of the codes.
Okay.
Generally, honestly, if you go to if you type in New York State VTL, I can find it. I have the summons app to the app. See if you can find it. That'll work. But any questions you have in regards to basically anything you potentially could be written a summons for?
Yeah.
New York State VTL, the vehicle and traffic law is public.
Okay.
You can just go look it up to see what you can and cannot be written a summons for.
Yeah.
So it'll be in there.
It's not. I couldn't find anything in the app.
I don't know how they would. How would they write it?
It's ridiculous. The vehicle and traffic law is 7 volumes of McKinney's, his books that we use in New York to track our state laws. 7 volumes. You're supposed to look through 7 volumes to find the specific law that says you can't have a camera on your helmet. And guess what? It ain't there. The vehicle and traffic law has a section 381 that describes what motorcycle equipment is appropriate. It doesn't say anything about having cameras or any other devices on your helmet. It's not illegal. The police are wrong. And the reason that they're wrong is because they're not trained to handle motorcycle equipment issues. So why would you run a checkpoint that's supposed to be about motorcycle equipment issues and use police officers who aren't trained in motorcycle equipment issues? Why would you do DWI checkpoints, drunk driving checkpoints, and use officers who aren't trained in making drunk driving arrests? It's because NYPD doesn't care about doing it right. They just do whatever they want. And if you want checkpoints done right, if they actually cared about the purposes that the courts have said you can do checkpoints for, then they would use officers who are trained in this way. And then innocent drivers would be excused quickly. If you believe, and by the way, I don't even believe in the drunk driving training that they have officers do. The idea that you're gonna have a guy with a high school diploma do a week of training, most of which is about the legal issues, and suddenly they can do ophthalmological and neurological testing. I think that's a bunch of baloney, but if you believe it, well, and that's the courts believe it, so if you're gonna follow what the courts say, then use the officers who are trained to do that. And they don't. They use officers who have no training whatsoever in making drunk driving arrests, and they send them out there in checkpoints, and they harass innocent people, and it's wrong. If NYPD used officers who were appropriately trained for the type of checkpoint that they were doing, the checkpoints would be less intrusive and more effective, and that would be better for constitutional law purposes. Intolerable and unreasonable to stop every automobile, subjecting all persons to the inconvenience and indignity of a search. We have the right to free passage without interruption or search without probable cause. So I hope this was helpful for you. I hope you found this interesting. And if you've liked this, please, check in the description below. You can buy my book about fair DUI to learn more about what's wrong with how we enforce the DUI laws and how we can make our roads safer. Also, a couple other videos you might find interesting. I did a video analyzing Tiger Woods' drunk driving arrest, which was handled, I thought, badly, especially he wasn't drunk, the officer lied about alcohol, a whole bunch of other things. And then Shea Wertz is an arrest where local police arrested a college football quarterback and claimed he had cocaine on the hood of his car. It was nonsense. Both of those are explained in these videos. Thank you.